Okay. What is the CLRC? The CLRC is a nonprofit organization, and our mission is to provide information and resources to help people understand their legal rights related to cancer. We are based on the educational model, which means that we generally don't give legal advice or represent clients directly. We are a program of the Disability Rights Legal Center, and our services are all free regardless of your income. Some of the resources that we have are listed on our website here, which you see on the screen. And attendees to this webinar can contact us with questions about today's presentation after talking at the end of this webinar. But if you have questions about a specific situation that you want information about, or you know someone who has questions about this topic, please instead fill out an online intake form, or leave a message if you need someone to help you fill out this online intake form. The online intake form results in quicker assistance, so I'll put this contact information up again on the screen a little bit later. We keep a lot of tools on our website, including webinars, handouts, and we recently created a patient legal handbook that contains information about various laws and is intended for newly diagnosed cancer patients or others who may want information about cancer and the law. Copies of the handbook can be downloaded through our website for free, or if you want a professionally printed copy for a hospital or larger group, you can contact us as well, and we can get that together for you. We provide information not just to someone who may have cancer, but caregivers, family members, professionals. So we have various resources designed for anyone who may be impacted by cancer. So what I'm going to cover in today's presentation will focus on genetics, specifically as it relates to employment discrimination and health insurance. This presentation will be relatively quick because the goal is simply to introduce you to some of the laws regarding genetic information and anti-discrimination. We don't expect you to memorize all the laws and be able to counsel people on the law after hearing this presentation, but hopefully you retain some information and share it with folks to alert them of their rights, and hopefully you learn something here that can help you be a better advocate for yourself or a loved one or a friend. So I will get us going here. What rights does a person have with respect to their genetic information? As you may know, genetics is a topic of concern for people with cancer, for people coping with genetic risk, and their relatives. Several issues and concerns can arise from genetic information in the employment and insurance realms. For example, someone might be worried that an employer could use genetic information to discriminate against them as a potential or current employee, or a person might be worried that an insurance company might use genetic information to determine premiums or impose a pre-existing condition exclusion. And of course, there are many privacy concerns when it comes to genetic information. So I'm going to quickly discuss hereditary cancer in general, and then I'll cover genetic testing and the state and federal laws that protect against discrimination. It's important to keep in mind from the beginning of this presentation one distinction. The laws that protect against genetic discrimination apply to people with asymptomatic genetic predispositions to cancer and not to those already diagnosed with cancer. You have to know there is a difference. Individuals with manifested diseases have different anti-discrimination laws that apply to their situation, but today's presentation is going to focus on the rights for those people who have a genetic predisposition to cancer and not an already diagnosed, cancer diagnosis. So to illustrate the difference, in case anyone needs some clarification, let's say a person has taken a BRCA genetic test to determine her risk of breast cancer. The results of that test are considered genetic information. So if someone's found to have a gene that can predispose them to cancer, that is genetic information. However, once a person has been diagnosed with cancer, the cancer diagnosis itself is no longer genetic information. Even though the manifested breast cancer could have been hereditary, it's not genetic information once it's already a cancer diagnosis. So I just wanted to illustrate that difference real quick. And then a person with genetic predisposition to cancer has the right to be free from discrimination and have their health information kept private. And that's to promote access to preventive care. We want people with genetic predispositions to take extra precaution and get the preventive care necessary. What are some common indicators of hereditary cancer? These next slides context for the legal part of the presentation. The CLRC, Cancer Legal Resource Center, as the name implies, does not give medical information. We provide legal information, but I did want to just give some background medical information here, some basic information that might help put this legal stuff into context. So just really quick, hereditary cancer, somewhere around 5 to 10% of all cancer is hereditary, and some common indicators of potential hereditary cancer. What do I mean by that? When does someone get alerted to cancer potentially running in the family? These things on the screen here could indicate that there's a potential for hereditary cancer. Things that might make a person think about getting genetic testing and talking to a genetic counselor could be multiple cases of one type of cancer within a family, more so if those are a rare type of cancer that are occurring in the family. Having family members with cancers occurring at younger ages than is common for that type of cancer, that could be indicative of hereditary cancer. For example, a family diagnosed with prostate cancer at 40 compared to the average age of a prostate cancer diagnosis at age 70 could indicate that cancer is hereditary. And then other possible things that might signal someone to get some genetic testing or hereditary cancer is having more than one type of cancer in a family member. Of course, sometimes the cause of multiple types of cancer for one person can be environmental or otherwise, but certain cancer pairings can indicate there's a hereditary cancer. For example, a person with both ovarian and breast cancer or with both colon and endometrial cancer might be more likely to have a genetic predisposition. Again, this is all maybe could indicate possible hereditary cancer, but just some things that might throw up red flags to have a person talk to a genetic counselor about getting tested for genetic predisposition. Anyway, that being said, this should be commonly known in today's age, especially as it becomes less taboo, but I just have to mention here that men can get breast cancer. So because so many men die each year from breast cancer, it's just an important thing we like to remind people about. So I mentioned genetic testing. What exactly is genetic testing? A family history of cancer can indicate an increased risk for hereditary cancer, and there are genetic tests available for some cancers to determine whether an individual has inherited the altered gene that's associated with an increased risk for cancer. In general, a positive test result means that the test found a genetic alteration. That does not mean that a person has cancer, and that does not mean that a person will definitely develop cancer. It means that a person may be at a high risk of developing cancer at some point in time. Now, what does a negative test result mean? That means that the test did not find a genetic alteration. That does not mean, as you might guess, that the risk for developing that cancer is zero. For example, if that person who wanted to get the BRCA gene test did not result in finding the BRCA gene, doesn't mean that they will never develop breast cancer. They could still develop breast cancer. It They just might not have that genetic predisposition for it. So a negative result can also be an inconclusive result. Maybe they could not determine whether the person had a specific gene, or it may just mean that the risk of that person developing a certain type of cancer is the same as the risk for the general population. Again, CLRC does not provide medical information, so these are the types of things that we just want to alert you to so that you can speak to a doctor more in detail about. Or at a counselor in order to make a fully informed decision about genetic testing. So you watch the CLRC webinar and you think, all right, my family had some of these signs. What should I do? Maybe I should consider genetic testing. Speak to a genetic counselor about what the legal implications could be, what the psychosocial and emotional factors could be if you do genetic testing. This is where genetic counseling is important. Cancer genetic counseling can help an individual determine whether they have inherited an increased risk for cancer and whether there are genetic tests available. And then what those test results could mean to an individual. Should you get tested? What will getting tested do for you? Will that help you prevent a certain type of cancer? These are the types of things you'd want to ask a genetic counselor. We urge individuals to find a genetic counselor by talking to their doctor, calling their insurance company, or checking this website, the National Society of Genetic Counselors. The webpage should provide some referrals to genetic counselors. Genetic testing is often pursued by individuals because if someone has an increased risk for cancer, they might want to get some testing, helping manage the risk by potentially increasing survivorship. And this is why there are laws protecting people against discrimination about genetic information. Individuals with a positive test result for genetic predisposition for cancer may decide to pursue medical options such as having increased surveillance or screenings, having preventive surgery, or having preventive drug therapy. Of course, decisions about what actions to take should be discussed with a medical professional such as a doctor or genetic counselor. And then, what is genetic discrimination? Let me just move forward here. Hang on just one moment. Okay, so genetic discrimination is the subject of this topic. So what is it in the first place? It is the social or economic discrimination that occurs based on an individual's hereditary predisposition to disease. It's basically when people are treated differently because they have a genetic mutation that may mean an increased risk of an inherited disorder. Remember, I just mentioned that a positive genetic test does not mean someone will develop cancer, but some people don't know any better and might assume so. So that's what genetic discrimination is. And I had a question here. Let me just see. Okay, someone asked whether we'll be able to get copies of the presentation. Yes, the CLRC is going to upload this presentation onto our YouTube channel and then potentially onto the website. So this webinar is being recorded and will be uploaded after the presentation is over. So thank you for asking that question, and I will continue the presentation. Moving right along here. So we know that genetic testing exists. We know that a person might want to get genetic testing so that they can protect themselves, so that they can prevent cancer from developing if they know they have a higher risk. and we don't want people to be afraid to take care of their health because of a fear of discrimination. So that's where these laws come into play. This is exactly why the laws exist, to protect people. As you may imagine, fear of discrimination has resulted in people deciding not to take genetic tests or to disclose family information to their doctors. But screening and genetic testing can be imperative for medical care, for prevention and early detection. And it's exactly for this reason that state and federal laws have been passed to protect individuals from genetic discrimination in various contexts. There are many different laws that apply to genetic discrimination, and each of these laws varies in the area of the law where it applies and what the law protects against. So I'll go over each of these. Essentially, I'm going to be primarily covering GINA, which is a Genetic Information Nondiscrimination Act, but I'm going to talk a little bit about these other federal laws, the HIPAA, the Executive Order, the Americans with Disabilities Act. So I'll discuss some of these laws in detail. All right, what is GINA? Not who is GINA. The Genetic Information Nondiscrimination Act is a law, it's a federal law whose reach expands over both employment and health insurance, and it prohibits discrimination in both arenas. The Equal Employment Opportunity Commission, EEOC, you may have heard of that. That's the federal body that enforces Title II of the Genetic Information Nondiscrimination Act, which applies to employment. Other federal agencies enforce Title I, which applies to health insurance. But I'm going to go ahead and dive into the details about GINA here. So GINA was eventually passed because proponents of the law argued that it was needed to eliminate fear of discrimination. We want people to take care of their health, we want people to get ahead of things, and it's better to prevent cancer before it develops. So the proponents of the law argue that it was necessary. I mentioned that fear of discrimination is a big cause of why people decline to take genetic tests, which could lead to early detection, diagnosis, and treatment for life-threatening genetically based conditions, such as various forms of cancer. After 13 years of negotiations, in 2008, President Bush signed into law the Genetic Information Nondiscrimination Act of 2008, otherwise known as GINA. This prohibits employers from discriminating against job applicants and employees based on genetic tests or genetic information. And it prohibits health insurers from restricting enrollment and adjusting premiums for health insurance on the basis of genetic information or genetic services. So let me break down the law here. First, when you're looking at any law, it's important to know the definitions. So under GINA, we know that it prohibits discrimination based on genetic information in health insurance and employment. So then the next logical question is, what is the genetic information that is protected under the law? Under GINA, it's illegal to discriminate against employees or applicants because of genetic information. So the genetic information this law is designed to protect employers and insurers from using against you includes an individual's family medical history, as well as the results of a genetic test for either the individual or their family member. Genetic information also includes the use of genetic counseling or genetic services and participation in genetic research. So employers cannot use any of this genetic information against you. Genetic information, however, as I mentioned early on in the presentation, it does not include already manifested diseases or if someone has been diagnosed with a cancer. That cancer itself, the diagnosis, is not genetic information, although it may be protected, but I digress. Let's see. So genetic information includes an individual's family medical history. So then the next question we ask is, who is a family member under that law? I mentioned the results of a genetic test for either the individual or their family member. Those results are protected under GINA. So the people who are family members for purposes of the law include relatives by marriage. And they are treated the same as relatives by blood. And half relatives are treated as family members the same as full blood relatives. That's because we don't want an employer saying, oh, this person's spouse has a genetic predisposition for a certain type of cancer, so we probably don't want to keep that employee around if their spouse is eventually going to get sick. So that's the purpose behind the law. So all relatives are treated the same as family members, but let me clarify. The following are considered family members, and their genetic information is protected under GINA as family medical history. First, second, third, or fourth degree relatives. Who's the first degree relatives? Simple. Parents, spouses, siblings, and children. Second degree relatives, grandparents, grandchildren, aunts, uncles, nephews, nieces. Third degree relatives are the greats, great-grandparents, great-grandchildren, great-aunts, great-uncles, and first cousins. Fourth degree relatives are the great-greats, great-great-grandparents, great-great-grandchildren, and children of first cousins. So all those family members are considered family members whose information is protected under GINA. Okay, so I'm going to switch gears here and move into non-discrimination in employment. Now that you know what genetic information, I'm sorry, I'm not switching gears, I'm staying in employment, but switching gears here to what information is protected to now who counts as an employer for purposes of GINA. Now that you know what information is protected, where does that protection apply? I'm going to first talk about it in employment. GINA became law and existing regulation. It applies differently to different types of employers. So GINA applies to private employers and state and local government employers with 15 or more employees. It also applies to employment agencies, labor unions, labor management training programs, and then it also covers Congress, federal executive branch agencies, and the Executive Office of the President. There's some additional laws that protect other federal employees, which I'll discuss later in the presentation. But essentially, the final GINA regulation explains that Indian tribes, as well as certain tax-exempt, bona fide private clubs, not labor organizations, are not considered employers under GINA. So in a nutshell, state and local and private employers of 15 or more employees, employment agencies and labor unions, and then some federal employees are covered as employers who have to abide by GINA. So then it offers protections to individuals in the workplace. What that means is that an employer is prohibited from discriminating against an employee because of genetic information or family genetic information. What do we mean by discrimination? So an employer may never use genetic information to make any employment decision because genetic information is not relevant to an individual's current ability to work. That means they can't hire or fire or reassign or promote or determine which benefits a person receives or any other term and condition of employment. Any of those decisions cannot take into account a person's genetic information, otherwise it's considered discrimination. It's pretty straightforward. So for example, if someone's boss knows an employee's mom had cancer, they can't deny a promotion for that employee because of a fear that that person might develop cancer because their mother had it. GINA protects job applicants, current and former employees, labor union members, apprentices, and trainees. So employers can't use this information against you. And additionally, an employer is prohibited from even requesting it. So they can't require your genetic information and they can't purchase it. And I'll go into some of the exceptions because for every rule, there are, of course, exceptions. GINA prohibits the employer from requesting, requiring, or purchasing an employee's genetic information or that of their family members, but here are the exceptions to the rule. The water cooler exception is called that because if an employer inadvertently acquires some genetic information, the employer is not in violation of the law. If they hear you discussing genetic information in the break room and an employer overhears the conversation, that is not a violation of GINA. So if you want your information kept completely private from the employer, it may be best not to discuss family members' cancer or other information where an employer could potentially hear that. If the employer has a voluntary health or wellness program that might ask employees to answer questions or undergo screenings, that's not a violation of the law. If the health or wellness program, some employers have those for like trying to quit smoking or lose weight or ride your bike to work. If you participate in a voluntary health or wellness work and acquire some information about your family medical history, that's not a violation of GINA. I will take a minute to just note that there's a bill that's been introduced in the House, so some possible legislation was introduced in the House this year that would potentially allow employers to offer incentives for people to provide genetic information. Basically, the bill proposes that employers can offer premium discounts to people who provide this information. Not just that, but for people who participate in these wellness programs. So we're keeping an eye on this bill because it seems like it could incentivize people to disclose protected genetic information who otherwise wouldn't if there's some big premium discount on health insurance. So just be aware, the laws are always changing, and we've been keeping an eye on things. So if anything changes with GINA, we will definitely be aware of that and include that in future presentations. But right now, if you participate in a voluntary health or wellness program, you disclose information. If your employer gets genetic information in that, that's not a violation of the law if you volunteer it. Some other exceptions. So an employer can't request your genetic information. One other exception is if an individual is requesting FMLA, Family Medical Leave Act, it's not illegal for employers to ask for information to comply with the certification provision. So FMLA is leave time. If you ask for medical leave to take care of a family member and an employer requests a certification, they get your family's medical information. That's not a violation of the law. Pretty straightforward here. If an employee's genetic information is publicly available, again, public information, the employer didn't ask you for it. Let's say the employer subscribes to newspapers or magazines or some other public periodical and finds some family medical history included in there, that's not a violation. Of course, they can't go purchasing medical databases. That would not be one of these exceptions. Social media, that may or may not count as publicly available information depending on the facts. So if an employer learns something about you through social media, it may or may not be the employer considered requesting genetic information. Kind of like the inadvertent water cooler exception. Let's say your username for Facebook or Instagram or Twitter is daughter of a survivor and you have a pink ribbon, they might be able to discern that you have a family member with cancer. Finding out that information is not considered an employer requesting your genetic information. So if they find that out, it's fair game for them to learn it. And then there are other exceptions like the law enforcement DNA human remains exception. I'm not going to go into great detail, but employers can request your genetic information for law enforcement purposes. Pretty narrow exception. Now, we know that employers can't request your genetic information, but we also now know that there are some exceptions to that rule. If they find out accidentally or they don't request it but inadvertently find out your genetic information, including family history, what do they do with it? Can they distribute it? No. lock folder here. That should be pretty clear. In all of those exceptions where an employer may gain access to your genetic information as an employee, the employer may not use that genetic information in any employment decisions, and they must maintain strict confidentiality. So let's say they do get a hold of some genetic information, it has to be kept completely confidential in a separate file, treated as a confidential medical record. If the employer possesses genetic information, they are prohibited from disclosing that genetic information to anyone except, again, some exceptions to every rule, if the employee requests the information. And then there are some other very narrow exceptions if the employer needs to give the information to an occupational or other health researcher in compliance with certain laws, in response to a court order, to a government official investigating compliance with the Genetic Information Nondiscrimination Act, or in connection with a certification for Family Medical Leave Act. Very, very limited exceptions. For the most part, they have to keep it under lock and key if they find out any genetic information. So hopefully that is clear. I'm now going to switch over to health insurance. I've given you some information about how GINA applies to employers, which employers it applies to, what information can be kept, what information counts as genetic information that can't be requested or used against you, and what the exceptions are, and even though an employer might end up getting a hold of your genetic information under one of the exceptions, they cannot use it against you, and they have to keep it confidential. So that's just a recap on the employment. Switching gears now, GINA and health insurance, I'm going to talk a little bit about that. So GINA protects against discrimination in the employment and the health insurance realm. For health insurance, it applies to certain types of health insurance plans. It applies to group health plans, such as those that you get through your employer, and to individual plans. It also applies to Medicare supplemental policies, Medigap policies, and it does not apply to the TRICARE military health system, to the VA, the Veterans Health Administration, Indian Health Service, or the Federal Employees Health Benefit Plan. So it applies to health insurance only. I'm not talking about these private disability insurance and things like that. I'm talking about health insurance. And again, there are certain places it does not apply, but there are other exceptions and other protections for those other types of insurance plans that I'll go over in a little bit. Okay, so GINA provides that health insurance issuers cannot discriminate based on genetic information. That means that they cannot use genetic information to make eligibility, coverage, underwriting, or premium setting decisions. Also, health insurers may not request or require individuals or their family members to undergo genetic testing or to provide genetic information. So it sounds kind of familiar. It sounds a lot like what the employment part of it, what the employment part of GINA prohibits. You can't request it and you can't use it to discriminate. So again, health insurers can't request genetic information. They can't restrict enrollment, adjust premiums, or otherwise discriminate against people for their genetic information. As defined in the law, genetic information includes family medical history and information regarding individuals and family members' genetic tests. Similarly to what I described in the employment context, GINA protections do not apply to manifested diseases in an individual, meaning that if a person already has a cancer diagnosis, GINA doesn't apply there. This applies to genetic information, genetic predispositions. So health insurance companies cannot consider genetic information as a pre-existing condition. That combined with the Affordable Care Act, the Affordable Care Act would cover manifested diseases that GINA doesn't cover. So GINA, Genetic Information Nondiscrimination Act, protects against discrimination for someone with a genetic predisposition. I mentioned that GINA does not cover people who already have cancer diagnosis, but the Affordable Care Act does. They consider a cancer diagnosis as a pre-existing condition. So together, the ACA, Affordable Care Act, and GINA mean that anyone with cancer or a genetic predisposition can't be discriminated against in health insurance. There are exceptions, as you might have guessed, or as you may already know, but just like with the employment context, health insurance companies cannot purchase an individual's genetic information. They can't request it or require you to take genetic testing. And remember, I'm talking about health insurance here. So that's a key distinction to note. The one exception for the rule that insurance companies can't ask you for genetic information is when a health insurance company generally pays for certain screening procedures like colonoscopies and other cancer prevention screenings, but they only do so beginning at a certain age. So for example, if an individual with a genetic predisposition for colon cancer finds out they have a genetic predisposition or it just runs in the family and they want to go get colon cancer screenings, colonoscopies at an earlier age than most insurance companies recommend it, then the insurance company can say, hold on, why would we pay for someone to get colonoscopies earlier than the recommended age? We only want to do that for people who really need it. So the health insurance company can ask, why do you need a colonoscopy before a certain age? Why you're 28, why are you asking for a colonoscopy? Or you're 30 years old, why are you asking for a colonoscopy? The insurance company can ask the person to prove that it's medically necessary, and then they've asked you for basically your family medical history, but they're only allowed to ask for the minimum amount of information they need to determine whether a procedure is medically necessary in order to pay for a procedure. So that's the one exception where health insurance companies can ask you for genetic information without it being a violation of the Genetic Information Nondiscrimination Act. Hopefully that makes sense. Okay, so let's say you suspect some discrimination and you see something that goes against what you just learned here in this presentation. Where do you report those violations? If an employer is discriminating based on family medical information, genetic information, in employment, you contact the same people that you would contact if there was any other discrimination for any other type of disability. You would contact the Equal Employment Opportunity Commission, the EEOC, and the EEOC can investigate a complaint for violation of GINA or the ADA. For health insurance, you would contact your state's insurance agency. Each state's Department of Insurance is in charge of enforcing the health insurance portion of GINA. And if the state's Department of Insurance fails to properly enforce GINA, then the federal government will reinforce the law. But this is where you'd start. The other federal and state laws that exist, that was GINA. So I just described Genetic Information Nondiscrimination Act, and these are some other federal and state laws that exist to protect against discrimination based on genetic information. So the Americans with Disabilities Act, I touched on that. If a person has a disability, and cancer can be considered a disability, and they are discriminated against in the workplace, the ADA is the law that provides that a person cannot be discriminated against. So to qualify for protection under the ADA, a person must currently have a disability or have a history of having a disability, or they can be regarded as having a disability. So if a person has a genetic predisposition for cancer, an employer might regard them as having a disability, meaning they treat you the same as they would a person with a disability. So an individual with a genetic predisposition for cancer could fall under this category as a protected class under the ADA, not only GINA. So if you're an individual with a genetic predisposition, you could be eligible for protection against discrimination under both laws. And then I mentioned that only certain federal employees are protected under GINA, but for those federal employees who are not protected under GINA, they're not out of luck. In February 2000, Bill Clinton signed Executive Order, which is EO, you may have seen that, EO 13145, which is the executive order that prohibits discrimination in federal employment based on genetic information. The executive order prohibits federal employees from requesting or requiring any genetic information from their employees and the use of genetic information in any employment decision. Sound familiar? Essentially the same protections as GINA, but this law is something different and defines genetic information as information about an individual's genetic test or genetic tests of family members, and information about a medical condition, disease, or disorder in family members of the individual. If you're a person who qualifies for protection under the executive order, it's important to look at the exact definition of the law because what I described about GINA is not identical to the executive order, but provides similar protection. So for the same reason that other anti-discrimination laws exist, this was signed into effect to encourage people in federal employment to get genetic testing and take care of their health without having to worry about discrimination in the workplace. Now, I mentioned that these laws, particularly GINA, applies to health insurance and employment. I'll go over a little bit about state laws now that I've talked about anti-discrimination under GINA, ADA, and the executive order. There may be some protection for these other types of insurance that aren't health insurance. So GINA applies to health insurance, which is your medical coverage. There are other types of insurance, though. There are life insurance policies, long-term care policies, disability insurance. Those are not covered under GINA. So federal law protects against health insurance discrimination in employment, but does not protect against these small other types of insurance plans. But for someone with a genetic predisposition to cancer, these types of insurance plans can be just as important as health insurance. And there may or may not be protections. So state laws exist to fill in those gaps in coverage. Some states have legislation that protects individuals against discrimination in life, long-term care, and disability insurance. So basically, the state laws might prohibit these types of insurers from collecting a person's genetic information or requiring genetic testings, but those laws might not prevent the insurance policies from taking into consideration a person's family medical history. So essentially, the protections are much more minimal where they exist, if at all. It doesn't offer as much protection from discrimination as the laws we just discussed. And again, just really important to keep an eye on the definitions. You want to ask questions like, what is the definition of discrimination? What is the definition of disability? What is the definition of genetic information if genetic information is protected? So just keep in mind that the definitions of these terms can vary across different plans, and they can determine what legal protection a person has. And so these are the terms to look at closely. And just like any policy, if you purchase an insurance policy of any type, you want to take a close look at the policy and see what the definitions are and whether you are protected or not, and what information is protected, how it can be used, how it can't be used. So always read the fine print and be aware that what counts as genetic information varies by state statute. Okay. Remember that life insurance is not one of those policies that's covered under GINA because, as you know by now, GINA applies to health insurance and employment. Only 17 of 50 states in the U.S. have laws restricting the use of genetic information in determining coverage for life insurance. So unfortunately, a lot of places that sell life insurance in most states can charge you more based on genetic predisposition. Same with disability insurance. Only 17 states currently regulate the use of genetic information. So unfortunately, it's something that we hear a lot. People are denied disability insurance because they already have cancer or they have a genetic predisposition to cancer, or they had a test that predisposes them to cancer, or that showed a predisposition to cancer. So only 17 states regulate the use of genetic information in disability insurance. And again, by disability insurance, I don't mean health insurance. I mean private insurance policies like AFLAC or other policies that offer some income replacement for short or long-term disability. And then long-term care, even less regulated by the states as far as genetic discrimination goes. Long-term care insurance policies, what do I mean by that? Those policies that reimburse people a certain amount of money per day for services that assist them with activities of daily living, like bathing, dressing, eating. That's long-term care insurance. And currently only 8 states have some kind of law that protects people against genetic discrimination in terms of long-term care insurance. So in a nutshell, you've learned today about genetic information, GINA as it applies to health insurance and employment, that there may be laws that protect certain federal employees, and that the ADA protects against people with manifested diseases or conditions, and that other types of insurance plans are not necessarily covered under GINA, and you'd have to check with your state insurance department to determine whether or not there's any protection against discrimination in long-term care, in disability insurance, or life insurance. But in most states, it's not considered discrimination if a private insurance plan charges you more if you have a genetic predisposition or denies coverage. But again, it's important to just check with your state's Department of Insurance. We've come to the conclusion of today's presentation, and I know that was a lot to cover in an hour, and I just want to invite any questions. I'll do my best to answer them right now, and if you have questions about a specific situation, if you're not sure, hey, I live in this state and I'm trying to buy a certain type of health insurance, please fill out an online intake form, because we'd want to know a lot more than just a general question. What county do you live in? What state do you live in? We do ask for your income information, but that's only so that we can determine the best resources to give you. Again, we don't provide direct legal representation, but we can provide information and resources. And I'm going to leave our contact information here if you need to contact us. Again, this session was being recorded for the ability to be able to upload it later onto our YouTube channel, and we should have those posted to our website too, so that you can watch this presentation later, including the slides. Those will be available when we upload that information to the website as well. It may take a little while for us to get this information uploaded, but if you, like I said, if you have questions about what type of situation that you have and what laws apply, I encourage you to fill out an online intake form here at clrcintake.org. If you don't have access to a computer, which if you're watching this, you likely do, or if you need help or someone needs help filling out an online intake, please call our phone number and leave a message and someone can help you fill out an online intake. So we want to try to make our services accessible to everyone. And again, our services are free, but if you feel inclined and you're able to, you can make a donation. All of that information is on our website. And I hope you found this presentation enjoyable. I'm going to stay online for another couple of minutes and see if people have questions. So I'm going to turn the recording off, and then I will go through the questions while we are not recorded.